It's now my pleasure to introduce to all of you Dr. Alice Jill Edwards, the UN Special Rapporteur on Torture and Other Cruel, Inhuman and Degrading Treatment or Punishment. She took charge of this Special Rapporteur post on 8th of July 2022. I was very impressed with the type of work that you have done, madam, in the last few years, and also your past before you became the UN Special Rapporteur. As the head of the Secretariat of the Convention Against Torture Initiatives, it's a very unique intergovernmental collaboration to achieve universal ratification and implementation of the UN Convention Against Torture. During the time, 15 new states joined the convention. This is a fantastic achievement of Dr. Alice Jill. 15 new states actually joined the convention. 180 states participated in capacity building activities and diplomatic visits. And we hope that you will also be able to have a similar effect on our country in terms of the ability to be able to influence with the type of work that we have done. For the benefit of all our members who attended here, in January 2026, Dr. Alice unveiled a new Survivors Charter for Justice After Torture called the Charter of Rights of Victims and Survivors of Torture and Other Cruel, Inhuman and Degrading Treatment or Punishment. This new charter that has been presented, it's a 9-page charter. I've been circulating it in the morning today. For others, you should definitely have a look at it. We will circulate it once we have all your email IDs or your WhatsApp numbers. The very important aspect about this new charter is that it examines what justice and reparation truly means to torture victims and survivors. Just for our Indian colleagues, the whole notion of compensation has been changed about 15-20 years back to reparation. With reparation, the notion of reparation covers not just the individual person who's been affected, but also the family, the community, takes into account not the physical injury, but also the emotional, social, and other injuries. Okay, this new charter that's been presented covers access to truth, effective investigation, participation in decision-making, prevention and protection measures shaped by the survivors' experience and voices. Today's meeting, we heard the survivors' voices. We heard what they had to say. I think it's up to us, the rest of us who are here, to be able to take it forward and also give shape to this new Charter of Rights that Dr. Alice has presented. Over to you, madam. I'm all waiting to hear from you.
You can go down now. Yeah. इसको दूसरी साइड फ्लिप करना
Again, it's something.
He changed it, yeah. You can see that.
The paper speech.
You don't mute, please tell us. The second we don't sense. Just speak.
Unmute. Please unmute.
Super.
Yeah.
Don't move it. Somebody don't touch it.
Just to check that you can hear me before I start. You can hear me before I start?
Yeah.
Yeah, please.
Okay, super. Sorry. First of all, Madame Srivastava and Dr. Suresh, ladies and gentlemen, thank you to the People's Union for Civil Liberties for convening this important discussion, and also for the kind invitation to be able to join you and to speak about police accountability and the prevention of torture and ill treatment. India is a country with strong constitutional traditions, a vibrant civil society, an independent legal profession, and a judiciary that has historically played an important role in safeguarding human rights. These are all important foundations and mechanisms for confronting serious human rights violations and challenges and strengthening the rule of law. At the same time, there are also commonly stated allegations of normalized and frequent use of torture and other violence in custody, coercive interrogation practices, and a very high number of unexplained deaths in police custody. These allegations clearly show that it's not merely isolated misconduct that is at issue, but deeper structural problems requiring urgent and deep-rooted institutional reforms. Particularly troubling are recent reports that I've seen indicating that between January and the 15th of March this year, the first 74 days of the year, more than 170 custodial deaths were reported in India. And Henry Tiffane of People's Watch already mentioned in his presentation around 20,000 deaths in India worldwide since 2014. These are truly shocking statistics. And behind them, of course, are individuals and the families of those individuals that have to recover and try and seek justice. These statistics, if confirmed, underscore for me a scale and seriousness of custodial violence and reinforce long-standing concerns expressed by many other human rights actors, including civil society in India and India's own institutions regarding torture, excessive force, and impunity. Allow me to highlight several issues of So I'm just hiking up I've never done that before. Let's see if that, is that louder? I always thought it was your end. I hope that's okay. Allow me to highlight several issues of particular concern. First, I've received and have acted upon persistent reports of unlawful killings and excessive use of force by police and security forces, what I understand are known as encounters and half encounters. Such incidents are often presented as spontaneous armed confrontations between police and suspects. However, credible allegations suggest that many involve staged events, the unlawful use of lethal force, and punitive violence outside judicial oversight. Even the terminology itself risks normalizing torture. References to half encounters, essentially shootings intended to maim or permanently disable and disfigure suspects, sometimes kneecapping, reflecting for me a troubling dehumanization of victims and a dangerous blurring of the lines between law enforcement and extrajudicial punishment. We know that these practices have occurred repeatedly in several states, in particular Uttar Pradesh and Assam, and that marginalized communities, including religious minorities, Dalits, Adivasis, and economically vulnerable individuals, have been disproportionately affected. As the Special Rapporteur on Torture, I recently sent a communication on those specific issues to the Government of India and held an in-person follow-up with the diplomatic mission in Geneva, but regrettably no response to my allegations has been received from the government. A second issue I wanted to raise is what we're here to talk about today, more specifically, allegations of torture and ill treatment in police custody. Information describes beatings, stress positions, electric shocks, sleep deprivation, threats against family members, psychological humiliation, denial of medical treatment, and sexual violence. Particularly alarming are reports of torture used to extract confessions, intelligence, and incriminating statements what is commonly referred to as a confessional torture. In many criminal justice systems, an over-reliance on confessions as the primary source of evidence can create what has been termed a confession culture. Systems inadvertently incentivize coercive interrogation practices where institutional pressure, public expectations, or even career advancement become linked to conviction and confession rates. And those confessions will be extracted by any means. Where confessions become central measure of investigative success, the risk of torture rises sharply. This is incompatible with human rights and fundamentally corrosive to justice. International law is clear that statements obtained through torture or coercion must never be invoked as evidence in judicial proceedings, except, of course, against alleged perpetrators of that torture itself. Moreover, evidence from psychology and neuroscience demonstrates that coercive interrogation techniques impair cognition, memory recall, and decision-making, thereby the risk of false confessions and wrongful convictions increase. By contrast, rapport and evidence-based interviewing methods, including those reflected in the Mendes Principles on Effective Interviewing, which was named after my predecessor in this role, Juan Mendes, as Special Rapporteur on Torture, are both more effective in establishing the truth and therefore more reliable in court and more consistent with human rights standards. Professional policing cannot be built on fear and violence. It must be grounded in legality, professionalism, forensic evidence, basic detective work, accountability, and respect for human dignity. Third, recent allegations concerning the illegal detention, abduction, and torture of 11 students and young activists by members of a special cell of the Delhi police in March this year are particularly disturbing. I understand that you've been discussing this case today. If verified, these allegations constitute grave violations of international human rights law and raise profound concerns regarding accountability, oversight, and safeguards against abuse. The fact that these were recurrent allegations involving some of the same young persons also suggests reprisals, recurring abuse, and institutional impunity. More broadly, concerns about torture and excessive use of force continue to be raised in several regions in India, including Kashmir, Manipur, and Chhattisgarh, particularly in contexts involving prolonged security operations and exceptional legal regimes. I think Henry Tiffan also shared a number of cases where at the very local level, there are also very serious allegations of torture, including extensive efforts of cover-up. And I think they highlight for me the need for re-education of all actors, including medical personnel and judicial magistrates. Excellencies, one of the most significant obstacles to prevention remains a lack of a legal framework compatible with international standards and a persistence of impunity. As you will know, India signed the Convention Against Torture in 1997. That is nearly 30 years ago, but has yet to ratify it. Although your constitutional protections and judicial jurisprudence prohibit torture and other cruel, inhuman, or degrading treatment or punishment, the absence of comprehensive anti-torture law is a major block to being able to address the issue of torture and ill treatment and police misconduct more comprehensively. And despite multiple attempts to put such legislation to Parliament, of which I was consulted on in a prior position on a number of occasions, this continues to create significant legal and practical steps in prevention, investigation, and accountability. Existing safeguards also appear to be inconsistently implemented. Concerns persist regarding delayed access to legal counsel following arrest, inadequate medical examinations, lack of audio or video recording of interrogations, insufficient implementation of CCTV monitoring in police stations, weak forensic documentation of injuries, and limited independent oversight of police and detention facilities. Some of these safeguards have been laid down by your Supreme Court, yet they remain unimplemented. In many cases, allegations of abuse continue to be investigated by agencies lacking full operational independence, while prosecutions and convictions of officials accused of torture or other misconduct remain exceptionally rare. Is your National Human Rights Commission properly equipped to deal with these complaints? We should never have police investigating police. Is there scope for, or does there exist in different states, police complaints authorities that are financially, politically, and substantively independent from the authorities they are investigating? The abuse of safeguards and India's failure to ratify the convention has also impacted diplomatic relations. For example, the failure to ratify the convention has prevented India retrieving wanted suspects in criminal cases in India. I'm aware of at least 2 individuals from 2 different European countries that remain abroad and at large because of this failure to be able to return them under threat of torture or a real risk of torture. At the same time, we can say that the recent conviction of 9 police personnel in the custodial deaths case in Tamil Nadu does represent an important and welcome moment of accountability. I think these cases are very good to study in depth, which I understand you are doing in some extent today, to find out the weak points in the different scopes, who's abusing, who's responsible for oversight, what are their fears about speaking up, how can they be protected, what role for the judiciary, what role for independent medical examinations and so forth. And what role also obviously for the courts in overseeing and being responsive when people brought before them claim to have been subjected to torture. What avenues exist for the judges and the magistrates to make specific inquiries? Yet I'd say that the rarity of these outcomes also underscores that the broader structural challenge is that custodial torture cases do not end up with effective investigation or prosecution. And this contributes to a wider perception of impunity and essentially getting away with it, and no push for the authorities to change their practices. Excellencies, colleagues, there are many good reasons for India to clean up its act. Preventing torture and police misconduct is the only thing capable of producing effective law enforcement. Accountability and professionalism strengthen public trust and improve the effectiveness of criminal legal institutions. But such accountability and professionalism needs a readiness of those authorities to receive constructive criticism and to reform accordingly. Sometimes we call this political will, but even at the level of the police commissioners, the police training academies, you know, there are steps that can be taken. I would recommend a revision. I'm not sure when the last one was undertaken, if at all, in the police academic curricula. The recruitment, pay and promotion systems, do they inadvertently encourage corruption, abuse of power, and ultimately torture and other violence? Codes of conduct of the police and security forces to be reviewed. And of course, as mentioned, police oversight bodies, whether that is the National Human Rights Institution, whether that is a separate entity, or also the courts. The present situation is, I'm afraid, a blight on India's standing internationally. Now, that's not everything. The most important is that people who come in confrontation with the law are treated with dignity and humanity at all times, and that if they do have complaints, that they are treated respectfully and safely. However, India, in the space that I occupy quite often in Geneva or in New York, India has regularly cited their human rights record in order to obtain seats on the Human Rights Council and the Security Council. They have even promised on multiple occasions to ratify the Convention Against Torture. Torture is regularly mentioned during the Universal Periodic Review. Yet getting India and all the relevant state authorities to see the need to change and that there will be great benefits in doing so does not seem to have filtered through. Allow me, therefore, to conclude with several recommendations. First, we need to continue to urge the government of India to take cognizance of the serious and recurring nature of custodial torture and deaths reported across the country, and to recognise that these incidents are not isolated abuses, but as indicators of deeper structural problems requiring comprehensive reform. And also for the authorities to see that the proposed reforms will lead to a more modern police force with greater justice outcomes and ultimately greater respect and cooperation with the police and security forces. Second, of course, India needs to ratify the Convention Against Torture without delay. It is the only South Asian country not to be party, and it is now only really within a couple of handfuls of countries worldwide who have not ratified the convention, and one of few democratic countries to still holding out. With that, of course, I understand the government's long-standing position has been national legislation is required ahead of ratification. That is not generally the position at international law. That is the position of India, and of course one needs to work with the view and the approach that India takes. But I would hope that that anti-torture law, of which there are several old drafts, could be resurrected. Third, authorities should ensure prompt, independent, impartial and transparent investigations into all allegations of torture, custodial deaths, enforced disappearances, sexual violence in detention, and police shootings. Such investigations have to be conducted in accordance with the United Nations manuals on the investigation and documentation of torture, the Istanbul Protocol, and the United Nations manual on potentially unlawful deaths, the Minnesota Protocol. I'm not sure to what extent those documents and their good practices that are contained in them are available and readily applied across India. And also, of course, a requirement to provide witness and victim protection and measures against retaliation and reprisals. It's very hard in a system where impunity is perceived to be real for a single individual or a group of individuals to really stand up and take this case, even with legal support, to take the case to its fruition. And there are obligations that the state provides those levels of safety and security for people who are willing to take their cases forward. Fourth, improved training, which is always said, but it's really very important, of investigators, prosecutors, and I would also say the courts, on professional investigative methods grounded in forensic evidence and effective interviewing consistent with the Mendes principles. And why do I say the courts and magistrates and the prosecutors? Because they need to be able to assess whether the evidence gathered and those interviews were in compliance with both your constitution, but also institutional law. And of course, if there are any needed legislative or operational instruments that need to be adjusted to allow this change in interviewing techniques. Finally, accountability mechanisms must be strengthened so that victims, lawyers, journalists, witnesses, and civil society organisations can seek justice free from intimidation and reprisals. It's a bit connected to what I said earlier. And perhaps India's fragmented ways of handling the complaints against the police and subsequent investigations need a wholesale review, or at least to be more readily accessible to those who want to bring cases forward. I've noted that there are a whole range of different ways in which complaints can be brought forward, but sometimes that plethora of ways actually undermines the ability for ordinary people to be able to take action. Ultimately, we need to find new ways to encourage and entice the government to see addressing these issues as in the national interest. It appears insufficient to continue to recite that preventing torture is a legal obligation under international law and under your constitution. We need to be telling them that it is fundamental to protecting human dignity, that it is about democratic governance, that it reinforces public confidence in the rule of law, and it will improve international relations. I just wanted to end by saying I know that my remarks are at a certain level of generality, and I'm conscious that many of you have been pursuing very important breakthroughs over many years. I hope nonetheless that these reminders of what needs to be done will contribute to meaningful progress toward these goals. I would like to offer my assistance in the future with this process, such as through conducting a study visit with a program of discussions with relevant actors and authorities. I offer you my availability, and I'm so pleased that Mr. Suresh has mentioned the new Survivors Charter. It will, and it is a groundbreaking document developed over 3 years with survivors from all different parts of the world who have really put their blood, sweat and tears into that document. And I'm really pleased to hear that you're looking at ways of how you can take that forward. And I would say, finally, we have some norms that are being written by survivors rather than only about them. So thank you very much for your attention.